Good morning, good afternoon, good evening, thereby depending on your location. Please join in the struggle to liberate our people from the contraption. Like and share videos now the update for this Thursday. You don't have the powers, you lack the legal capacity to detain Mazi Nnamdi Kanu in DSS hell. Ejimako tackles the Supreme Court over the continued detention of Mazi Nnamdi Kanu in DSS hell. Now talking about the special counsel, Alo Ejimako, has been firing the Supreme Court of Nigeria over the continued detention of Mazi Nnamdi Kanu, as the federal government of Nigeria has been using them as a cover. That's according to Alo Ejimako. He said they are being used as a cover to continue to detain the leader of the IPOB, Mazi Nnamdi Kanu. Of course, he said they don't have the enormous powers. Yes, the powers to release Mazi Nnamdi Kanu does not lie exclusively on the Supreme Court. That's what Alo Ejimako is saying. Alo Ejimako was clarifying issues when he made a statement which he titled, "Releasing Mazi Nnamdi Kanu is not an act of mercy, but an act of doing the right thing." Yes, Ejimako clarified that the cause for Mazi Nnamdi Kanu's release should not be misconstrued as pleas for mercy. That is what he said. Now let me quote him verbatim now. I quote, "The matter of releasing Nnamdi Kanu is not an act of mercy, executive clemency, or even amnesty. Instead, it is an act of doing the right by simply complying with a subsisting municipal court order or the standing international tribunal decision that independently declared his detention illegal. Alternatively, the decision can also properly proceed through a sound invocation of the copious constitutional provisions on discontinuation of prosecution such as this one that is irredeemably unsustainable. It is pertinent to note that in the previous but related matter of the infamous proscription of IPOB and the attendant criminalization of its vast members by the Nigerian government in 2017, I promptly levied a continental legal challenge against the proscription, and in March 2018, the Continental Tribunal ruled in favor of Nnamdi Kanu and IPOB and accordingly directed the Nigerian government to reverse the proscription and cease and desist from any further law enforcement actions against Nnamdi Kanu and IPOB members. Thus, the subsequent rendition of Nnamdi Kanu, the arrests, the detentions, the tortures, the disappearances, and the widespread extrajudicial killings of IPOB members should not have happened, and had the authorities complied with this landmark continental decision. It is relevant to stress the fact that following the rendition, I had also initiated a complex constitutional suit against the government of Nigeria, and on 26 October 2022, the Federal High Court ruled in favor of Nnamdi Kanu and accordingly declared both the extraordinary rendition and the consequent detention as flagrant violations of the Constitution. Thus, Nnamdi Kanu's release from detention vested from the very day this judgment was given, and the days are still counting to this day because the judgment is extant and not stayed. Therefore, if Nigeria truly respects her constitution and her courts, it will be needless to be constantly calling on the authorities to release Nnamdi Kanu on a competent judgment that unambiguously ordered his release. As a bona fide member of the United Nations, Nigeria is bound by treaty and customary international law to faithfully comply with this directive. Failing to do so stigmatizes Nigeria as a nation, the same institution that passed the historic resolution that legalized self-determination and thus saw to Nigeria's independence. In view of the foregoing, it is a fallacy to suggest that releasing Nnamdi Kanu from detention is an act of mercy, and failing that, an event that must await the uncertain conclusion of the appeal currently pending and delaying before the Supreme Court. To be sure, Nnamdi Kanu's fate does not lie in this appeal alone, but alone, because the appeal is but one of the several cases that were triggered municipally and internationally by the extraordinary rendition, and all the cases are independent, of equal stature, and aimed at securing Nnamdi Kanu's release. Therefore, the different moments in time when two of these several cases, in particular, the one initiated at the Federal High Court and the one initiated at the United Nations, both of which have concurrent jurisdiction over the rendition, were determined in favor of Nnamdi Kanu. The narrative that freeing him lies exclusively in the hands of the Supreme Court is fundamentally false. It is also malicious, prejudicial, and profoundly injurious to Nnamdi Kanu's legal interest, especially as it offers the authorities the umbrage and easy political cover to persist in the illegal detention of Nnamdi Kanu. Finally, it needs to be emphasized that for the obvious reason that Nnamdi Kanu is neither currently facing any trial, nor does he have any charges standing against him, his detention is in reality an imprisonment without conviction. In plain terms, he is a victim of forced imprisonment by the states, a rough and tough imprisonment that is more horrendous when the locale is not a prison or is not in prison or a correctional institution, but a hideous DSS cell which is no different from a Dank police cell, or even worse in some ramifications. End of quote. Now this is the statement from the special counsel. He said, look, for people who are having the notion that it's the Supreme Court that is keeping Nnamdi Kanu, he said it's not true. They don't have the powers to do so. That Nnamdi Kanu has been released, yes, and acquitted by the appellate court. And Nigeria is bound to obey the international treaty that recognizes self-determination, that Onyendo committed no crime, no offense, and therefore the United Nations Working Group on Human Rights and Arbitrary Detention have declared him free, and rather they told Nigerian government and that of Kenya that they committed illegality and they're supposed to compensate Nnamdi Kanu adequately and apologize to him. Therefore, on that strength, Nnamdi Kanu has been released and the Supreme Court has no powers to keep him back. So anybody who is asking for clemency, leniency, is making a grave mistake. So it's not out of mercy. Oh, but Tinubu, please release Nnamdi Kanu. We are begging you. Someone said, I am your son. I think that should be Yul Edochie. Yul Edochie, the actor, yes, the son of Pet Edochie, said he's begging his father, Tinubu, to release Nnamdi Kanu. He said, my father, I'm begging you, your son. Why begging him? He's not doing any favor to Nnamdi Kanu or the Eastern Nigeria or Igbos or Biafrans. He must obey the court directive. They are stigmatizing Nigeria in the international community. So the continued detention of Nnamdi Kanu will continue to haunt Nigeria, whether they like it or not, to continue to propel them in the international community in the negativity. You see, you have seen the economy of the country. I have seen it has nosedived. The worst economy in the whole of Africa. That's the Nigerian economy. The currency is like a tissue paper. Just go, you will understand. It's like a tissue paper. The unemployment is high. You have seen the insecurity everywhere is protracted. So, and nothing is working in this conception since particularly 2015. So it gets worse from the moment they kidnapped Nnamdi Kanu and renditioned him extraordinarily. And today they are facing many challenges that seems insurmountable. Yes, as long as they remain in this contraption, as long as this contraption remains, those challenges are insurmountable.